In this session, we will continue our discussion on the principles from the employment contract chapter. Let's talk about OSHA. OSHA is confusing in that OSHA is an acronym that's used to refer to both the law and the agency that enforces that law. So OSHA is the Occupational Safety and Health Act, which is a federal law that's designed to establish a safe and healthy work environment for employees. And that act is enforced by the Occupational Safety and Health Administration. So the two changes between those is act and administration. But the administration is the federal agency that has the responsibility of enforcing OSHA. Now, OSHA is a federal law, federal regulation that covers it, but OSHA is been adopted to some degree in all of, or not all, but a majority of states have adopted a comparison, an analogous state law to OSHA. In Tennessee, it's called TOSHA, the Tennessee Occupational Safety and Health Act. And more or less, the TOSHA has adopted almost uniformly the provisions from the Occupational Safety and Health Act. And so the state law is very much just a adoption of the federal law. So under OSHA, employers have a duty to provide a safe and healthy workplace. And so these obligations take multiple forms, but the two most common ones are that employers are required to cure or correct any workplace hazard that's identified that could cause an injury. So if you've got employees up working on an elevated area, you've got to have like handlebar or some sort of railing around it to prevent an employee from falling off. If they're working at a certain height off the ground, you've got to have the ability for them to harness and strap themselves in to protect against falling. So those are some of the requirements that you would be required to do to abate these workplace hazards that could cause injury or even death. And then OSHA also ensures a safe and healthy workplace by requiring employers to provide and make employees use protective gear. So this is hearing protection if it's allowed, manufacturing facility, make them wear hearing protection to prevent against hearing loss, wear eye gear glasses to protect against harm or injury to the eyes, maybe wearing gloves, and make it be a situation in which you're wearing some sort of protective vest or jacket or bodysuit. So these are the two things that OSHA really pushes to provide a safe and healthy workplace. So to make sure that the employers are complying with the OSHA standards, the agency has authority to come in and inspect workplaces. They can come in to make sure that you have put in the railing, that you have protective eye gear or headgear that you require your employees to wear. So the inspector who will come in from OSHA has broad authority to ensure compliance, and they usually do this in a number of ways, but some of those common ones are they will walk around the actual workplace and ensure that they don't observe any hazards that you've missed to avoid or to correct. They'll also usually interview employees and make sure, are they making you wear eye protection, hard hat? Are they making you wear hearing protection? Whatever it may be, but they're going to ask about also the hazards that they may be subjected to. Do you have harness equipment to strap in? Things like that. They also will review company records. The company records may show them a pattern because you have some, and we'll see it on a slide in a moment, some record keeping obligations under OSHA. And so if you look at company records and you see a pattern of the same conduct happening, then it kind of indicates that there may be some lack of training on safety procedure use, or there may be a lack of safety equipment available to avoid those injuries. And also, it's common to come in and test protective gear systems, make sure that the equipment's there, make sure that the um, fire system is working, whatever it may be. They will test and make sure that the safety equipment that is designed to avoid workplace hazards or harms is in fact protecting against those harms and hazards. So if there is a violation that the inspector finds, if they find that you don't have railing in a certain area, then they're going to write you a citation. And so once you receive a citation, the employer is required to, as quickly as they can, correct that violation. And if it's not corrected, then the agency has the authority to seek an order to compel the employer to comply and to fix the problem. So the civil penalties, there are a number of civil penalties that are awarded here. You see that they range from thousands of dollars to hundreds of thousands of dollars, on some of them to up to $12,675. And so you can see that these violations can become very costly. The book gave you some examples of where I think like BP had been hit with over $80 million in a year. But these penalties can become very costly, and so the purpose of it is to encourage employers to comply with the safety and healthy workplace requirements set forth by OSHA. So in addition to these civil penalties, it's possible for the administrative agency to refer a case to the Department of Justice for possible prosecution on criminal charges. So the referral is usually done in one of two instances. One is for a willful violation of the safety rules that results in death. So there's got to be a violation of safety rule that results in death. If someone just gets injured, even if it's a very serious injury, including something like paralysis, it would not be enough. It has to result in a death. The other referral basis is where the employer has provided false information to the agency. So if they've misled the agency and there's a degree of an intent there, then it would be enough that the Department of Justice could pursue criminal charges. Now, the willful violations that results in death, the penalties for that is up to a $250,000 penalty for individuals and up to $500,000 for the corporation. And you could also have a possible imprisonment of up to 6 months. Of course, a corporation can't be imprisoned. Those would be individuals. For providing false information, it has penalties of a $10,000 fine and imprisonment of up to 6 months. So the criminal prosecutions, although we've talked about these, they're extremely rare. So while it's a tool that's there, it's not one that's often used to encourage employers to comply with OSHA. So the biggest threat is the civil penalties that we talked about. That's what is the main motivation behind employers complying with OSHA, because it's very unlikely that they would be prosecuted criminally for not complying with OSHA. And so since the 1970s, we talk about how rare these are. Since the 1970s, there have been less than 100 cases that have been prosecuted. And honestly, it's not surprising, because when you think about the federal crimes and the things that the Department of Justice handles, there are areas and laws that are much more important for them to be overseen and enforcing than the OSHA laws. So in addition to the requirements of keeping the workplace healthy and safe, OSHA also imposes record-keeping requirements and posting requirements on employers. So as an example, employers have to keep certain records that document the critical information about the work-related injuries or illnesses. So when there is an accident and someone is harmed, or if someone contracts a workplace illness, then the employer is required to fill out a form. It's called the OSHA Form 300. There are other forms than just the Form 300, but the Form 300 is the one that is usually used to memorialize and document work-related injuries or illnesses. And so as the employer, you've got obligations to keep those records and to make them accurate. But in addition to keeping records, you've got to post certain information. You've got to post a job safety and health poster. This is a poster that is universal. It's put out by OSHA, and you've got to have that posted in your place of employment. You also have to post any OSHA citation that you receive, and you've got to post also notices that you receive of imminent danger. So in addition to keeping these records and posting these requirements, employers are required, in the last couple of years have been being required to submit electronic records of the workplace injuries and illnesses. Now let's talk briefly about workplace violence. Workplace violence is a very real event that can happen in the workplace. You see plenty of instances on TV, reported on the news, where there has been a workplace shooting or a shooting that happened somewhere that is a business, whether it's at a restaurant or at a school. A school is technically a business. You have workers there that would give rise to potential liability for the school system. Shooting that happens at a nightclub or a bar, a restaurant, whatever, the bar, the restaurant, the nightclub, that's a workplace as well. You have employees, and they could give rise to liability for the employer. So the two most common ways that you see employer liability in workplace violence is through workers' compensation and tort claims. And by tort claims, we're talking about the negligence that we covered in the previous week. So let's talk about workers' compensation first. So if workplace violence occurs and you have an injury to the employee is more than likely entitled to workers' compensation benefits. So the book, so far, we haven't covered workers' compensation, and I don't think the book does. Workers' compensation, every state has a form of it, but it is specific to each state. So Tennessee has its set of workers' compensation laws, Mississippi would, Alabama would, and so on. And those laws determine how an employee is compensated for injuries that he or she sustains while on the job. So if you are working at Walmart and you're carrying some boxes of food to restock a shelf, and you slip, fall, and land on your back, and the boxes land on top of you, and you tear your rotator cuff in your shoulder, that's an injury that happened at work in the course and scope of your employment, and under workers' compensation laws, you would be entitled to medical treatment as well as potentially benefits to cover any permanent impairment you have, as well as any time that you would be off work. So workplace violence, if there is violence that happens in the workplace and you're injured, then you may have a claim for workers' compensation. There may even be a claim if you're not physically injured, because you may have a mental injury. Something like PTSD could be very common because of a traumatic workplace violence incident. So an example would be is a few years ago there was a shooting at a bank in Jackson where there was, it grew out of, this is my understanding based on the papers, it grew out of, it was an ex-boyfriend or fiance or husband, but he came in and shot and killed his ex-spouse, girlfriend, fiance, whatever the relationship was at the time, but came in, shot and killed her, and killed himself. I don't think anybody else, as far as employees, were injured, but there could have been PTSD claims because of what they witnessed and saw happen that day. And so injuries that happen in the workplace, and these would be your employees, this would not cover independent contractors, but your employees may have a claim for workers' compensation benefits. For there to be a claim, like we've talked about with several different types of claims that we've studied so far, you have to have causation. And that means the injury must arise primarily out of and in the course and scope of employment. So you're looking for that connection to the injury to work. If there's that connection to work, then you're going to be entitled to medical benefits and medical treatment. So we see the two phrases there. It's got to primarily arise out of, and then in the course and scope of employment. And the course and scope requirement refers to the time, place, and circumstances under which the injury occurs. So it's connecting the event to the actual workplace. So it happened at a time you're at work, it happened when you're at work under some circumstances in which you're working. The arising out of is usually the key component in these type claims. And the arising out of refers to a causal connection between the employment and the injury. So the course and scope is trying to connect it to the physical location of work, and the arising out of is that causal connection that links the injury and your employment. So in Tennessee, there is basically a continuum of 3 different classes of assaults. On the one end, you have assaults that have an inherent connection to employment. The assaults that have an inherent connection to employment would be compensable. Those would be claims that would have the causal connection that's required, and the employee would be entitled to benefits. So these would include things where there's a dispute and an assault over job performance, pay, or termination. There's a case in Tennessee where 2 employees got an argument over the one employee's job performance. A few minutes later, the one employee took a shovel and struck the other employee in the face, causing a broken nose and some other injuries. That was an assault that was compensable because it happened at work and it arose out of the work relationship, because the catalyst for their dispute was job performance, which has an inherent connection to employment. On the other end of the spectrum, you have assaults that are inherently private. These are assaults that maybe take place in the work setting, but it's usually the result of a domestic or the private life and not something that's exacerbated by employment. So on the one end of the spectrum, you've got assaults with inherent connection that would be compensable, and on the other end, you have assaults that have an inherently private connection, inherently private dispute, and those are not compensable. So there's a case, use another Tennessee case, there's a case where husband and wife had separated because of the husband's having an affair. Well, the wife went and got a new boyfriend as they were separated. The ex-husband or the separated husband saw her out with this boyfriend. It enraged him. He came to her place of work the next day. She worked at a pharmacy, came to that pharmacy and ended up stabbing her and killing her. And they sought workers' compensation benefits, and the court said, no, this is an inherently private dispute. This is something that grew out of a domestic dispute that they had, and it had no connection whatsoever to employment. The only connection it had was that the assault took place at her work. And so the assault could have happened at her work just as much as it could have at her home or at somewhere else like Walmart or Kroger parking lot. And so it was an inherently private dispute, no connection to the employment setting, and therefore it was not compensable. So you've got those 2 ends of the spectrum, and then in the middle you have assaults that result from a neutral force. And these are claims that are in the gray area, if you will, to where it may be compensable, it may not be. It depends on the facts and circumstances of the employment. An example of these are random assaults on employees by individuals outside the employment relationship. As an example, in Tennessee, there's a case where a lady worked at a driver's testing station, and she was there. She noticed that a vehicle was parked blocking the entrance area. She walked in and announced and asked for that person who was responsible for that car to move the car out of the way. someone followed this lady outside, came up behind her, grabbed her, and pulled her close to him and whispered in her ear some sexual references. And she struggled and pulled away from him and tried to kick him, and he jumped in the car and drove off. And that was a random assault, and it didn't have necessarily any connection to the employment other than it happened there. The court analyzed it and they found that it was a neutral force, but they found it to be compensable because they reasoned that but for her employment, she wouldn't have been subjected to that person grabbing her and saying those things to her. And her claim was one of PTSD. So that's an example where someone didn't have necessarily a physical injury, but she claimed a mental injury because of the assault that she was subjected to. So you see that there are three classes of assaults. You may have some assaults that would fall into having a connection to the employment, and that's going to be compensable. Then you're going to have the ones on the other end that are inherently private, and those are ones that are not going to be compensable. And in the middle, you're going to have these assaults resulting from a neutral force, someone random outside of the employment relationship, and those may or may not be compensable. So that kind of covers workers' compensation, and so we'll briefly look at the tort liability aspects. So who can recover on tort liability? Well, you could have employees who don't qualify for a workers' compensation claim. So it could be an assault that's inherently private, or it could be one of the ones that's in the middle, but they just found that it's a neutral force and there's not enough of a connection to the workplace to make it compensable. So if they don't have a viable workers' compensation claim, then the employee may be able to sue the employer based on a tort negligence theory. Now, the employee, under Tennessee law at least, is precluded from having both a tort action as well as a workers' compensation claim against the employee. Workers' compensation by statute is the exclusive remedy. So if the injury is a workers' compensation one, so it's one that has the connection to the employment and it's compensable, then that employee is going to be barred from alleging any sort of tort negligence claim against the employer. So a negligence claim by an employee is only viable for employees who do not have a workers' compensation claim. The second class of persons who can allege a tort liability claim would be third parties such as customers, clients, and vendors. So in these scenarios, liability will hinge on whether the employer owed a duty to the injured party. So this should be real familiar. We're going right back to negligence, and we're talking about, did they owe a duty to the injured party? So the general rule is that there's no duty to control the conduct of a third party to prevent the third party from causing harm. But a duty will exist in a special relationship to either the third party or the victim. So an example is a business owner and a patron. So you own a business, to your customers who are coming in, you have a special relationship, and there may be a duty to control the conduct of a third party to prevent that third party from causing harm. So while the case law in Tennessee says that owners and occupiers of business premises are not general insurers of the safety of their customers, potential customers, or the general public, they don't insure them against everything, but they do have a duty to use reasonable care to protect customers and potential customers from unreasonable risks of harm. So it goes right back to what we've talked about previously in our negligence analysis. So in the criminal context, businesses will have a duty to use reasonable steps to protect its customers from foreseeable criminal attacks. But businesses can also be liable for accidental, negligent, or intentionally harmful acts of third parties if those acts are foreseeable. So let's do a couple of examples. So in the criminal context, if you are a retail location and you have a parking lot, it doesn't have lights, so it's dark in the parking lot at night, and you've had over the last 18 months 6 robberies or assaults that have occurred, then that's going to make it to where you're going to have a duty to take reasonable steps to protect your customers because a criminal attack is going to be foreseeable. You know you have bad lighting, and you know that criminal acts have happened in your parking lot in the past. That's going to put you on notice such that you have a reasonable duty to protect against these foreseeable criminal attacks. How can you protect? You could put lights in the parking lot to make it to where people can be seen and harder for somebody to make an assault or a robbery. You could also put video cameras out there and make it known that you're videoing. You could lastly perhaps put a guard who's there. If you did those things, then you're taking steps to protect your customers from foreseeable criminal attacks. Now, let's take an example of where a business could be held liable for an accidental or negligent harmful act of a third party. Again, let's say you're a retail store. Let's say you're somewhere like Home Depot, and you have somebody's back shopping in the carpet area, looking for a rug, and there's a big roll of carpet, and you have a 9 or 10-year-old kid who's playing on it, and he ends up pushing the carpet, and it rolls, and it knocks and hits over a customer. Well, you may be liable for the accidental negligent act of that 9-year-old kid because it could be foreseeable that a roll left out could potentially be pushed and roll out. That is an example of what could be an instance in which a business would be held liable for the negligent act or the accidental act of a third party. So the degree of foreseeability to establish this duty to protect against criminal acts will almost always require that there's been prior instances of crime that have occurred on or in the immediate vicinity of your premises. So that goes back to the example we gave where I said there's been 6 attacks, I think is what I said, in 18 months. That's going to be your prior instances of crime. That's going to give you that foreseeability to create a duty for you to protect against those criminal acts. Now, that duty that you have to protect is limited to only criminal activity that occurs on your business premises, on your property. And that should make sense because your only duty is to protect, and you can only protect on your property. Similarly, for the conduct of an employee, if there's a criminal act by that employee, then the duty is limited to conduct that occurs in the course and scope of employment. So again, let's take another Tennessee case as an example. There's a case where the employer ran a carnival, and they went from town to town and would set up and stay for a few days or a couple of weeks maybe and have a carnival, and people would come to it. There was an employee who was at the carnival. He was working there. He saw a female there. He followed her off the property and was following her home, and as she was walking home, he pushed her into a vacant lot or in a wooded area, something, and ended up raping her. And she sued the carnival, the employer. And her argument was that it was foreseeable what he would have done, and they owed her, the employer, the carnival, owed her a duty to protect her against this employee because the employee had a bad history of similar incidences, and the argument was that they should have been able to foresee what he would have done and should have owed her and others a duty to protect against this individual. The court found that there was no liability for the carnival because 2 reasons, the exact 2 that we're talking about. The duty of that employer, the carnival, was limited to activity that occurred on its business premises. And once they had left the carnival and she was walking home and it happened on this wooded, secluded, vacant lot, that's not on their property. They had no duty to protect there. Also, they found that they owed no duty because the conduct by the employee happened outside the course and scope of his employment. He was not working at the carnival anymore. He had followed her home off the business premises and was not performing any acts in the course and scope of his employment.